Yes, Mr. Mack.
My lord, if you wouldn't mind just giving me one moment. My computer's firing up and being rather slow.
Yes, so is mine, so.
I'm grateful.
Yes.
I'm grateful, my lord. Lord, I appear for the appellant in this matter. My learned friend, Mr. Oldham, KC, appears for the respondent local authority. Matter of housekeeping first. Can I just check? You should have 3 bundles. So core bundle running to 279 pages.
Yep.
Then a supplementary bundle of 348 pages. I think there have been various iterations of that. And an authorities bundle with 14 cases in it.
How many pages in the supplemental should we have?
So supplemental should be 348.
Yes, I do have that.
And then you should also have a better quality image of Appendix 3 from the supplementary bundle. I'm grateful. So what I propose to do is just make a few opening remarks and explain the overall structure of my submissions, and then I'll get into the bones of it.
Can I ask about the 7th witness statement of Mr. Buter? There's an application adjourned to today for that. As I understand it, all that's doing is updating us as to what's happened on the sale process.
That's correct, my lord.
And what's the, because there was a bit of uncertainty about the date then. Is there any update on that?
There's further update, which is that there has now been apparently a final agreement between the parties that the fallback date or the long stop date should be pushed back to the 17th of June.
Yeah.
So we wouldn't be asking this court to give judgment unduly.
Thank you.
And of course, my lord, there's no objection to that being admitted. So my lord, this case concerns a decision by the Cabinet of the local authority to privatise 2 care homes. That's Castle Grange and Claremont House. The claimant is Brenda Hughes, and she brings this action by her son and litigation friend, Mr. Pygott. The claimant is a resident of Castle Grange, and her son, Mr. Pygott, as well as many other families, have grave concerns about the decision to sell these homes to the private sector. And they are concerned about the impact on vulnerable residents and the quality of care. The rationale for privatising these homes was that it would save money. But we say that the information provided by officers to the Cabinet about the potential savings was flawed in 2 fatal respects. Firstly, the headline saving figure was based on costs of alternative provision that was 2 years out of date, as the judge below found. And secondly, that officers, having identified that some savings were possible, that savings whilst continuing to have the homes in public ownership, they did not provide information about those savings to the Cabinet, who were the ultimate decision makers. So those are the 2 fatal errors, we say.
Don't we need to be clear about the nature of the public law error, which you say those 2 inaccuracies or 2 mistakes gives rise to, in the light of all of the concern that was at first instance about the pleading of the case and the discussions in that connection. And it seems to me, speaking entirely for myself, that what you are complaining about is most aptly described as the officer's report being misleading.
My lord, I think there are different ways of framing it.
But it's the officer's report that is the kernel of your argument, isn't it?
Yes.
Yes. And there is quite extensive jurisprudence about how one approaches an officer's report to members and when such a report can give rise to legal error. None of which we seem to have here, or none of which seems to have been provided to the court below. But it does seem to me that, speaking entirely for myself, it would be helpful in taxonomizing the legal error that you're describing. I know it is described in the judge below as being an error of rationality, but actually what is concerning, as I understand it, your clients, it is the content of the officer's report, which must be taken to be the members' reasons because they simply adopted the officer's recommendation, which brings into play an awful lot of authority about how one should approach officers' reports.
So, my lord, I think there's perhaps a distinction between the two errors. The one that the judge found was a legal error, and he found it an error on the basis of procedural irrationality, the way that he put it. In that respect, my lord, it is the case that we say that the report was misleading. It said the savings were X. In fact, even on the local authority's own methodology, by the time we get to the 2025 to 6 financial year, it was 40% less than that. So yes, that's the case in respect of the non-updated figures, if I can put it like that. And of course, what you don't see in the officer's report is any explanation saying this is likely to be a very significant underestimate or overestimate of the savings because of inflation and the fact that we're now paying more for care homes in the private sector. My lord,
but I think if that is your criticism,
yes,
it would be worthwhile thinking about cases such as Mansell that deal with the question of how a court should approach an officer's report and what the threshold is for establishing what is probably a species of rationality, namely that a decision has been arrived at on the basis of an inadequate, I'll use as neutral language as I can, an inadequate officer's report.
Well, my lord, I can certainly look at that over the lunch adjournment.
Thank you.
If necessary, provide a short note on that in due course, if that would be helpful to the court.
Yeah, and then as to the second species of error that you identify, that is, as I understand it, an absence of information.
Yes.
That you say the members should properly have been arrived at.
Yes.
Is that a Tameside point, or is that a point about the officer's report?
Well, again, my lord, I say that there are, if you like, different boxes that you could put it within. So clearly one could frame it simply as a Tameside argument. There may be irrationality both on the part of the officers, because they knew that there were some savings that could be made, and apparently had turned their minds to it, and yet did not provide that information.
Yeah, but I think it's quite important for us to be rigorous about this,
yes,
because they may all end up with the answer irrational, okay? But they have different routes to reaching that answer depending upon whether there are error in the officer's report, whether there are failure to undertake further inquiries to satisfy yourself of certain issues. And there's a danger if you simply, as the judge did, focus on rationality. You're using an extremely broad brush to examine what is, on any view, a very detailed decision.
Yeah.
So we need to find the right routes through the material in order to get to the right answer. So that's why I'm asking you, is it a failure in the officer's report? Is it a Tameside point? What is it?
So, my lord, with the second...
Yeah, I'm on the second one.
Yes.
Yeah.
I would say that I would put it both as a failure in the officer's report, but also as Tameside, in the sense that essentially no rational decision maker could have made this decision, which we say turned on the extent of the savings, or the extent of the cost benefit to the local authority, without having this information. Now you could then, I think, further divide it up into, was that a failing of the officers or a pure rationality failing on the part of the Cabinet?
Well, the Cabinet, in this decision-making process, the Cabinet, I don't know whether this is going to be disputed by your opponent, but the Cabinet simply adopted the, say simply, it's not meant to be pejorative, but they simply adopted the officer's recommendation. They didn't depart from it, they didn't amend it. So in those circumstances, is there any difficulty in taking the officer's report as the reasons why the members reached the decision they did?
No.
If that's right, we don't need to look at anything other than the officer's report, do we?
Well, no, we don't. So, save that I will be saying in due course that, of course, when it comes to Section 31 of the Senior Courts Act, the fact that we don't know how different factors within the officer's report weighed on the thinking of the Cabinet as the democratically elected decision makers is relevant to whether you can be satisfied or the judge below could be satisfied that it was highly likely that the outcome would not have been any.
We only get there when we've identified correctly what the species of public law error is,
Yes.
and therefore whether or not it will be highly likely, if that species of error had not taken place, that the decision would have been similar or would have been the same.
Yes.
Yeah. Thank you.
So those are the two errors. What Upper Tribunal Judge Ward...
Have we got Tameside in the authorities bundle?
My lord, we don't.
Have we got Plantagenet Alliance? So I think that's the last word on it.
The summary of, relevant summary of Plantagenet, the key paragraph is cited.
It's cited by the
in
judge.
the judgment,
Yeah.
yes.
Yeah. So we don't need any more than that.
No, my lord, I'm certainly content to proceed on the basis that that accurately summarises the applicable legal principles.
Thank you.
So, my lord, Judge Ward found that the failure to consider an unformulated alternative could not give rise to judicial review on rationality grounds. That's the way that he framed his decision. But the, if you like, the practical consequence of those words was that he was saying it was not unlawful for the officers not to put before the Cabinet information about the extent of possible savings. The second finding that he made, and we've already touched on this, is that he found, applying sort of ordinary, if I can put it that way, rationality principles, that the failure to provide updated figures was irrational. But of course he went on to apply Section 31 of the Senior Courts Act and found that it was highly likely that the outcome would not have been substantially different. So that's where we get to where we are now. I advance two grounds of appeal. We say the judge was wrong on both of those points. Ground one challenges the decision in respect to the failure to provide figures of the extent of potential savings, and ground two challenges application of Section 31. So, My Lord, I propose to structure my submissions in 5 parts. First, I'll set out a number of general propositions which underpin both grounds of appeal. Second, I'll take you to the key documents, and that really will be that February officer's report plus the appendix. Third, I'll then address you on ground 1, fourth on ground 2, and finally, I will address you on the arguments raised in the respondent's notice. So there are three propositions which underpin my arguments in this appeal, and the 3 are these. First, that the decision to sell the homes turned on the extent of the savings that could be or were likely to be achieved against budget. And I emphasise the word extent. Second, that the Cabinet, as democratically elected decision makers, had to weigh the extent of the potential savings against the risks and potential disbenefits of sale, and third, that without accurate information about the costs of alternative provision and the savings that could be made whilst continuing to run the homes in public ownership, the Cabinet could not properly discharge this function, i.e. the function of weighing the extent of potential savings against risks and disbenefits. So those are the 3 propositions. I'm going to briefly expand upon them before going on to the other parts of my submission. So that first proposition, that the decision to sell the homes turned on the extent of the savings that could be or were likely to be achieved against budget, is made good first by looking at the judgment and aspects of the judgment which are not challenged by the Council. So I'd invite you to turn to the core bundle, page 127. And at paragraph 147, we see the judge's finding that although the Council's decision primarily relied upon savings in the revenue budget, which were claimed to result, other factors also played a part, and then he describes them. So that's the judge's finding of what the primary factor was. And we see similar references to that being the primary reason at paragraph 83 and also at 63.
Sorry, could I have those references again?
Yes, so 63 and 83.
Thank you.
So that's where we have the reliance on savings against budget. And then the Council's own case is that they were not proceeding on the basis that the homes had to be sold or closed unless they could run on a cost-neutral basis. I'm afraid the reference in my skeleton argument was wrong, but it's the High Court skeleton where they make this point. So it's page 146 of the core bundle.
Which paragraph?
Paragraph 63, where they say nor is it right to assert that the Council proceeded as though any savings must fully close the gap. Nothing in the report says that. Noting that any efficiency or cost savings will not close the gap is not akin to asserting that unless they do, there can only be one decision. So we see clearly there they've disavowed any suggestion that there could only be one decision unless there was complete cost neutrality. So it must follow as a matter of logic that this decision turns on the extent of the savings. So that's my first proposition. The second proposition then was that the Cabinet, as democratically elected decision makers, had to weigh the extent of the potential savings against risks and disbenefits. Now, it's said by the Council that concerns about risks are all speculative. But if we look at their own risk assessment or impact assessment, then we can see that they have identified a high risk. And that's in the supplementary bundle. Page 162. Where we can see age, impact on residents or service users, level of impact, high, type of impact, negative, and then in the text, they do make the point that residents would remain in the care home that they're currently residing in. However, there could be transfer of care provider, and then a transfer to alternative provider will ensure continuity of care. But the change could also have a negative impact on existing residents due to their complexity of need. So there's an identified risk there. We also know that there is widespread public concern and opposition, including from the litigation friend of the claimant in this case. I accept, of course, that the judge found, I won't take you to it, but paragraph 30, he found that certain fears about potential outcomes could be countered by monitoring by the council team CQC contract negotiations. But the fact remains that these are risks. Mitigating factors cannot eradicate all risk. And it was still a matter for the Cabinet, not officers, as those who are democratically accountable, to determine what level of risk they were prepared to take, particularly against a background, we say, of this widespread public concern. So that was a weighing exercise that necessarily fell to the ultimate decision makers, the Cabinet. And then the third proposition, that without accurate information about the costs of alternative provision and savings that could be made, the Cabinet cannot properly discharge their function, in my submission follows necessarily and logically from the first two propositions. If it's a decision that turns on extent, and the weighing of the extent against risk was for the Cabinet, without information about extent of savings, or accurate information about extent of savings, they can't properly perform their function.
I mean, it may come down to what you mean by accurate, mightn't it? Clearly, if the savings were said to be 860,000 and they were only 800,000, I don't think we'd be here, would we?
Possibly not. And my Lord, again, I will get into the detail, but I say, just standing back and as a matter of common sense, there are other peripheral details, but essentially the Cabinet receive a report which says, we recommend this option to you because it will save £800,000. and actually it will, in fact, save only just over half that.
Well, that only reads a part of the report, doesn't it? Because there were other savings recognised that will be made, but they weren't calculated. So there's the difference between actual and budgeted costs, and there's the capital savings over time that were likely to be made. So all those were in the balance as well, weren't they? And none of those were quantified. So
and the capital receipt from sale, if sale proceeded.
My Lord, in relation
as you drew to the court's attention to the paragraph where the judge goes through all of those factors.
Yes, and specifically in relation to capital receipt from sale, and again, I'll take you to other bits of the judgment, but the judge talks about entering the realm of speculation in relation to whether there even would be capital receipt at the time of the report. The report simply said there could be. Similarly, in relation to the savings on capital expenditure, the judge found that those figures were not robust, and you see the word "could" in the report. The 1.4 million appears to be the highest figure that's ever cited, and in various other reports there's different figures. And then
but there would be capital savings necessarily, wouldn't if you no longer have to, you no longer own the buildings and need to keep them in shape. And the point is they weren't quantified accurately presumably because it wasn't thought necessary to go to that level of detail.
That's why where we started from is the jurisprudence in relation to officers' reports are quite important, because picking up my Lord Justice Zacaroli's point about how accurate is accurate, that's where we need to be careful what the test is that we're applying here. Yes. Anyway, you're going to have a look at that for us.
So if I can then move on to the second part of my submissions, which is looking at the officer's report. And that's in the supplementary bundle. I'd invite you to start at page 258. Yes, please.
Thank you.
So we see there that there is the heading number 2, and this is the February 2025 report. The heading is information required to take a decision. And all of the factors under this heading are financial considerations. So you first have at 2.1 budgeted savings, and in relation to that, we know the judge's finding that these, because they used a non-updated figure for comparison of provision in the private sector, this estimate was 40% 40% wrong. So the correct figure would have been 524,000. I won't take you to the judgment now, but that's reflected in the judgment of paragraph 53. So that is substantially wrong.
Just examining that question wrong.
Yes.
That word wrong. Mathematically, this is correct. Savings estimated on the basis of this document. There's no error of maths here.
No.
The numbers for the actual costs, if it remains in council ownership, are based upon 2025-26 budgets.
Yes.
The fact that the figure for alternative accommodation was based of 85269 was a historic figure.
Yes.
Is known, because it's the same figure in all the previous reports.
But my Lord, what is not known or not presented to Cabinet is that over that period there has been over a 10% increase on what the local authority generally pays care homes.
So just for my benefit, to be clear, the 85269 should have been, because you gave us a figure for what the...
It should have been 524.
No. The 85269, which is the external cost of provision.
Yes.
I think it's about 938, isn't it? If you add 40, oh no, that 10%.
We had a very precise figure for the savings, so there must be a.
Perhaps if I could come back to that, but it would be.
What was your figure for? What was your substitute figure for the 867,295?
So that was 524,000. It's in the judgment at paragraph 53. Give you the exact figure. Yes, so it's 524,761.
Paragraph again?
That's paragraph 53 of
53,
the judgment.
thank you. 524.
524. Apologies, I just closed the page. 524,761.
Thank you.
In terms of the weekly figure, I don't have that at my fingertips, but it would be
10.7% higher.
10.7% higher than the 85269.
I may have missed it. Did the judge refer to that? He must have done some sort of calculation to arrive at the figure, presumably in paragraph.
Yes,
53.
So he.
Or did he just gross up?
He grossed up, yeah. So he didn't separately calculate what the weekly figure would have been.
Thank you.
So that is why I use the word wrong and I say misleading, because it is presented as a direct comparator to the 2025-6 budget as what it would actually cost. And these are presented in terms as savings against that budget, in circumstances where we know that in the generality of cases, the local authority was paying at least 10.7% more. If we then move on to the actual historical overspend, again, the text in the report does not actually reflect what is shown in Annex C. So at 2.2.4, the text states the care homes have historically operated at a level of overspending against budget, and then it gives one example of the year 2023 to 2024. I'm sorry to descend into this level of detail, but I think it is important. If we then look at the actual figures, if you do have that better quality copy, and this at the moment they're talking about expenditure because they deal with income under the next heading. So on the second page of the document there's a heading Castle Grange and Claimant Summary 1.3, and this page provides figures for Castle Grange. If one goes down to the line that says, highlighted in yellow, total direct costs, there we can see variance against budget each year. And for Castle Grange, in the year 2020 to 21, these figures are slightly odd because they appear to have 20 to 21 twice with different figures. But what we certainly see is that figures in the second and third column show that in fact expenditure was less than budget for 2 of those years. So in 2 of those columns, that's where you see minus 141,474 and minus 33,493.
Is there any magic in the fact that those were the COVID years?
Well, my lord, not necessarily if one then looks at the Claremont House figures.
Just to be clear, when we're reading this, the minus appears somewhat divorced from the figure, but that's how it reads, is it?
So, my lord,
the minus sign.
Yeah, yes. That is. It's a little difficult to see because it's right at the extremity of the column, but
yeah.
If one does the maths, it certainly is the case. One can see that if you look at budget,
well, that's sufficient for me. Yes. But I just wanted to be absolutely sure of course, that was how I was supposed to look at it.
But if we then look at Castle Grange, you actually have an underspend against budget for every year.
Do you mean Claremont?
Yes, apologies, yes, Claremont. Yeah, my mistake. So that's next page. It's summary 2.3. It says. Again, looking at the same row, we can see underspends in every year except the first one, including the projection for 2024 to 5. Only other point that I highlight.
Sorry, I'm obviously being very slow, but your point is what? The sentence at 2.2.4.
It gives the impression that there has consistently been an overspend against budget. When one descends into the detail, it's actually more often than not, there has been an underspend. And then the report chooses to pick out the one year which has the greatest overspend and presents it as though that is sort of representative.
Well, depending on their eyesight, all of this material was before the members, wasn't it?
It was, yes.
Yes, yeah. It's just helpful because you provided it very helpfully separately, but it was an appendix to the officer's
report. It was, yeah, absolutely. Yeah. But I say this will be relevant when we come to look at the judge's reasons for applying Section 31 and the extent to which one could proceed on the assumption that there would be an overspend against the 2025 to 6 budget if the homes remain in public ownership. There's also just one thing that I want to flag, because my learned friend makes quite a lot of points about agency workers, the fact that they weren't in the budget. But whilst it is right when one looks at these figures, and it's the top set of figures that have direct staff wages. So the first set of figures is headed employees rather. We see there's direct staff wages, direct staff employer contribution, direct staff additional costs, and then agency is the final one. But there's an underspend for direct staff in each of the years where agency workers are employed. So again, when thinking about the significance of these agency workers, if any, it's important to bear in mind that you're employing agency workers because you don't have a full complement of employed staff. So it's not a matter that there will just automatically be this exceeding of budget.
Sorry, you say there's an underspend on direct staff when the agency staff are employed?
Yes. So if we look at every...
Are you looking at Castle Grange or...
So I'm looking at the moment at Claremont.
All right, because that's not the case on Castle Grange, I don't think.
I think it probably is. If one looks at the line that says direct staff : wages,
yeah,
and then follows that through.
There are minuses in every column.
Yeah.
Admittedly, still at the very beginning of the column, the minus separated by some space from the actual figure, but the minuses are there.
So, well, they are for 2 out of the 3 years, aren't they?
My lord, I have them as negative for all of them, but
Okay.
again, it's quite difficult to read because you have
Here's
the figure
even
at
light
the
on my
top.
glasses on. It's minus 428, minus 776.
Oh, I see. I'm looking at the wrong column. A line, yes. Yes, I see.
Thank you. So, my lord, if we can then jump back to the report. Supplementary bundle, page 259. You then have income. And under this, it simply refers to income from residents' fees and contributions offset against costs of running the homes, therefore reduces net budget. However, whilst resident contributions help, they do not cover the full cost. Council therefore must cover the shortfall. What this report does nothing about is it does not address the fact that they had already identified, the officers, that some savings could be made by charging more. And we see that, I'm just going to jump to it briefly, in the previous December officers' report, which is at 173. 173.
Would all of these reports have been before Cabinet?
Yes, and they would have seen all of them. I don't think, and I'll be corrected if I'm wrong on this point, I don't think that they would have been resent the previous reports for the purpose of the February meeting, but I quite accept that they were available to Cabinet members, and you should assume that they have long enough memories to remember what was said in the previous reports. I don't take any point on that.
Some of the early reports were in fact background reports in the successive stages of the decision-making process. Sorry, Peter.
So if one then looks at this December report at paragraph 2.18, that's where the officers identify that continuing to operate the homes as an option, there is the potential to make some savings by way of staff changes and by increasing fees for self-funding residents. Although the cost disadvantage the council faces versus the private sector on staffing is likely to make operating such facilities on a cost-neutral basis almost impossible. So they said in terms there can be some savings. One of them is specifically by increasing fees. And then they say it can't be cost-neutral, but we already know, and I've taken you to the High Court skeleton argument, that the council disavow any suggestion that they were proceeding on the basis that it had to be cost-neutral in order for it to be a viable option to do anything other than sell or close.
There's more detail about the difficulties in terms of raising fees, though, isn't there? Somewhere in the information that was before Cabinet. Maybe it's in this call-in report.
Yeah, so that information, what went to the scrutiny panel didn't go to Cabinet.
Ah.
There is a little more on that. For example, but again, it's very broad brush. One of the slides to the scrutiny panel says essentially that there's a difference of X £100,000 between cost of private provision and the cost of currently running it. If we split that between all 7 residents, we'd have to charge them vast sums. What it doesn't say is, we think, looking at the market overall, it would be viable to increase charges for self-funders by X. And it doesn't say, so that all of their analysis proceeds on the basis that occupancy can be increased above the current low levels at these homes. So that their calculations are generally based on 90%. So what you don't see is, well, if we generally increased occupancy and we charged a bit more, this is how much we could get from it. And that's what I say is the critical.
But is there any evidence about that, and any evidence about what costs they might be able to obtain from those who are self-funding, bearing in mind that those people presumably are seeking a place in a care home in an open market?
So we do have the evidence that the claimants submitted,
Yes.
about the local market rates.
Yes.
And that shows that they were significantly higher than the rates charged to self-funders. So we did have that evidence of fees for comparable homes, and it was quite significantly higher.
Why would it be that the fees that a council actually achieved for those who were self-funding was so much lower than the fees that those people would have been paying had they sought to obtain a place in the open market?
Well, my lord, we don't have any detailed analysis from the council on it. What it appears is they charged 820. They don't appear to have increased that at any time during the course of this dispute. We know that for several years they had been focusing on, if I can just put it this way, getting rid of the homes, initially planning to close them, then planning to sell them. During that time, there were a lot of news reports about what was going on. There's been quite a lot of publicity about this case. It's not surprising that in those circumstances, family members of someone with dementia wouldn't be rushing off to send their loved
That would have a
ones to
chilling
these
effect
homes.
on
Of course.
somebody wanting to take a place in the home.
Absolutely.
Yes.
So, my lord, if we can then, and lady, my lady, if we can then turn back to the February report, 259 of the supplementary bundle. The next one is avoiding obligations of capital investment.
Page again?
259.
Thank you.
The judge analysed information about avoiding capital investment and found that the figure was not robust. And that is in his judgment at paragraph 151. I don't propose to take you to it now, but that will be significant when then looking at the section 31 point. And
Does it really matter? I mean, it's obvious that there would be savings. Does it really matter, the accuracy of the figures themselves?
well, my lady, I say yes. And I go back to those propositions that I set out at the outset, that once one accepts that this wasn't about any savings being sufficient to justify sale, the council specifically disavow that, then it necessarily becomes a case about extent and degree. It's the cabinet, democratically elected members of the cabinet then who must weigh up the options, knowing the extent of the savings. So that's why I say it is significant. and the figures put forward do seem to vary quite widely. If we then move on to the final point, which is capital receipt, the report states that the exact amount of capital receipt for sale cannot be disclosed at this stage as work on the potential transfer of both care homes has been paused. It's important to note that this receipt is not included in the 867. And then importantly it says, should a capital receipt be generated, this would be used to repay existing council debt. And that's where the judge talks about this being in the realm of speculation. We don't know. And of course, what's being sold here, and we know from this document and others, it's not just a building that can be used for any purpose. It's a building that will be used under contractual terms that require it for a period of time to be used as a care home and restrict the extent to which that provider can increase fees. So it's not self-evident that they would be getting market rate or anything like that. And here it's not even said for sure that they would necessarily be getting any capital receipt. So we then go to the conclusions. Again, we see at 2.6.2 that the primary focus is on this saving of 867 million. They say it's been modelled on a prudent basis, a high level occupancy, and then talks about the council can only save in budget terms what is already stated in the budget. 2.6.3, it then states that in reality the operating costs for both homes have been, so that's a historic statement, higher than budgeted, and that's not actually accurate. Some years they have, most years they haven't. And the real terms benefit would therefore be higher for the following additional factors, and it talks about avoiding overspending against budget. But in fact, when one drills down, that appears to be based solely on the false premise that there'd been a historic overspend when actually there hasn't. And some years there has, some years there hasn't. What that isn't based on is any sort of projection or analysis that we've made this budget, and ordinary principles of budgeting are that you set a budget based on what you think things are going to cost you. We've made this budget, but we already know that it's actually going to not be met. That would be odd, to say the least. And the judge stated at paragraph 51 of his judgment that there was no reason to conclude that the 2025-6 budget was not accurately stated so far as the costs were known. So I'll then skip through some of the other bits and go straight to the final parts, which set out the options. That's 266 of the supplementary bundle. At 6.1, the options are stated as A, do nothing, continue as is, B, pursue the transfer, C, close the homes. The judge found, and I've not challenged, that reading the report as a whole, do nothing did not mean that the council had its face set against any changes. But what we don't see in this options or anywhere else in this document is an explanation that if the do nothing wasn't face set against any changes, what in fact was the likely cost of continuing to run the homes in public ownership, if sensible and prudent measures were taken along the lines of those that the officers expressly identified could be taken.
So those measures being, so that we're clear.
So the two things that the officers expressly identify are staffing changes and increasing charges to self-funders.
By staffing changes, is that a reference to agency staff,
We don't
or is
know.
it a reference to overall staff? Or?
We don't know. It would be speculation.
I mean, presumably, in order to get a CQC assurance, one would need to have a certain level of staffing in place.
Yes.
Yeah. But that's not something about which there is no evidence as to what, for instance, the minimum staffing levels might be and what that might cost.
No, but of course, we simply have this statement in the December report which shows that officers thought staffing changes could achieve savings, and nothing as to what those changes might be. My Lord, I could speculate as to other things. It might be that shift patterns or contracts, if they're paying lots of overtime, there's all sorts of things, my Lord, but I would be speculating.
So the two points are staffing changes or increased fees.
Yes.
Yeah.
I mean, another way of looking at it is that the officers didn't go into detail on those because they assessed the savings as being not worth drawing to the Cabinet's attention when making this particular decision, taken together with everything else that's in their report.
But we don't actually see them ever turning their mind to that.
Well, they have turned their mind to it because they mentioned it in here. But if, as officers, they reach the view that taken overall, the savings are just de minimis in the context of the larger decision that has to be taken, why would they descend into detail on the extent of the savings? They are advising the council.
My lady, if that were the case, but what we don't see is in Mr. Booter's witness statements even, is him saying, we have done some rough calculations, this is how much it would have saved, we didn't put it to the Cabinet because we thought that was de minimis, not material. I accept I would be on much weaker ground had they done that, but we do not see that at all. So that is the key document, this February document, plus the appendix on which the decision was based. And I'll turn now to address you on my grounds. The ground one concerns the failure to provide information about savings. And in a nutshell, what we say is that because the decision to privatise the homes turned on the extent of the savings that could be achieved by sale, accurate information about costs of continuing to run the homes in public ownership was mandatorily relevant information to this decision.
You don't need to worry about that because they've provided it. I mean, in the sense that the purpose of the officer's report was to give that kind of information.
Yes, and they didn't give it. So this is the cost of continuing
the
to
question,
run. Yeah.
The question, as my Lord Justice Zacaroli put, is what do you mean by accurate, and where is the threshold crossed between material which, as a matter of judgment, is put by the officers before the committee to inform them about the decision they're reaching, and illegality?
Yes. And in that regard, I come back to the point that here we don't see the officers working it out themselves and then making a decision not to provide this information to the Cabinet. So if we were in a situation where you had, for example, in a witness statement, we did some initial calculations, they would have saved £10,000, that wasn't material. I accept that in that situation I would be in difficulty, but here the unlawfulness, and that's why it probably is best characterised as a pure Tameside challenge in this sense, is that they know that there's the potential to make some savings. They've got that far. They haven't done the work, even the back of the envelope work, to say what those savings might actually be. And so they weren't in a position to then make an informed judgment about whether it was material for the purposes of putting it to the Cabinet members.
If it's a Tameside point, you have to establish, don't you, that no reasonable authority faced with this decision would have failed to make the inquiry as to what that thing that they had described, namely savings or increased fees, no reasonable authority would have proceeded to decide the issue without making those inquiries.
Yes.
Yeah.
That's the threshold. And I say, because this is about extent, until you have some idea about what those savings might be able to achieve, you can't make an informed decision. And this isn't about some sort of nebulous idea that in general they ought to have been looking more at what savings could be achieved. We see from the report that there are two specific areas where the officers have said there could be savings, and they're not, that they've failed to either themselves actually work out what those savings might be in practice.
But the judge considered that proposition, didn't he? And at paragraph 83 of the judgment, having directed himself in relation to the Tameside duty, didn't accept below your submission that that duty was breached by the failures to investigate. This was ground 2 of your claim, wasn't it?
Yes.
So the Tameside arguments were in fact addressed not under ground 1. So it takes me back to my opening point about the importance of rigour in pleading public law errors. So, in fact, what you're now arguing as a Tameside error in ground 1 was dismissed by the judge in ground 2.
Yes, my Lord. What I say is that it can be seen through the prism of sort of pure irrationality or Tameside as an aspect of procedural rationality, and that we see the judge's reasons both at paragraph 59 and at paragraph 82 and 83.
But it seems odd to suggest that the judge was right under ground 1 to say it was irrational, and then to have concluded under ground 2 that the Tameside duty was complied with.
Well, the judge, I think the judge finds it into, if perhaps we could just go to those bits of the judgment. So core bundle 108.
Yeah.
This is where he deals with Tameside, and halfway down paragraph 82,
Yeah.
he says in terms save for the out-of-date figure used.
Yeah.
So he is sort of hiving that off.
Yeah.
And it might be that he would have found that that was a Tameside error as well. So there's no inconsistency between his Tameside findings and his irrational.
Well, he goes on, even if, contrary to my view, the council were to be required as a matter of law to have made further inquiries about the financial consequences of alternative options in this case, as noted, there was no alternative option put forward other than sale as a going concern or continued operation by the council. And then he goes on to say it was not meant to be unreasonable to fail to inquire into the causes of overspend, and so on.
And my lord, what I say is we see here in 82 and also back at paragraph 59 that I'll go to in a minute. One of the key errors, perhaps the key error, is this assumption that there was somehow a duty on the part of the claimant or other third parties. So we see that when he says there was no alternative option put forward other than sale as a going concern or continued operation. Now, insofar as he is referring there to being put forward by others, in my submission, this isn't a matter where there is an onus on others.
No, but what one's entitled to conclude, as I think the judge was that the options that have been presented represented a reasonable basis for decision making without a notional reasonable authority being required to investigate more. That's the Tameside duty.
Yes.
Yeah. So what he's saying is they had enough information, they didn't need to do more.
And what I say is that when we look at that analysis, that's partly informed by an assumption that in order to be required to do more, you would need to be having third parties putting forward the option, and that is wrong in law. And we see...
Well, I think you have to put that sentence in the context of the earlier paragraph where the judge discusses the decision-making structure, which was, I mean, he says of local government, but in truth, that was taken in this case, which was that there was a sequence of iterative reports analysing various aspects, and then the scrutiny committee intervening and saying the cabinet should have far more and more transparent financial information, which finally leads to the officer's report.
So my lord, if I can take you to another part of that sentence, so it's partly where we say the legal errors lie, and I accept that the judge, having made a judgment, I must identify some errors of approach and not simply disagree with him. But it is both in putting the onus on others and in this statement in the middle of 82, which I do also highlight in my skeleton argument, but that it's consistent with decision-making structure of local government that officers must, up to a point, be able to sift out material which they consider to be not realistically viable. Of course, I accept that, but there's absolutely no suggestion anywhere in the evidence that the options identified in the December report were not viable. They were stated in terms, and I've taken you to it, that there are two things which could achieve savings. The officers thought it was viable to increase fees, and they thought it was viable to make staffing changes. So this is not about viability, and I say that is a clear error to be framing it in that way.
Do you say that they should have gone on then in the officers in their report to have said, here are two areas where savings might be able to be made, but we've had a look at those and consider them not to be realistically viable? Couldn't have been any complaint if they'd gone on to say that, could there?
Well, my lady, that would be, I think, wholly inconsistent with what they are saying, because they are saying they're viable. These are things that could happen. So,
depends what you mean by viable, doesn't it?
Exactly.
There are things that could be done.
Yes.
Would they do it? Would they make this a decision which was in the council's interests?
And my lord, that's why we come all the way back to my initial propositions about if it's actually for democratic decision makers to weigh. There are these public concerns and there are these risks, however much they might be mitigated. How much money are we prepared to pay to ensure that the residents of this home continue to get excellent care without disruption? And that's why, fundamentally, I say you need a level of detail in this report and not just simply there are some savings that can be made. But in terms of the viability point, I would certainly read viability meaning something that is not workable. And that is distinct from not material. The judge could have said, to sift out things which are not material to the overall decision. And if that's what was meant, then my answer is that we don't know whether it would have been material, because that required the officers to at least do some modelling, and we see nothing in the evidence. I've said there's some very, very high-level stuff in the scrutiny panel, but it's not at any point saying this is what we actually think we could achieve. This is the best case that we could achieve. And having not done that, they can't assess materiality. Perhaps whilst we're on the judgment, just to sort of complete the picture, we go up to paragraph 59 as well, because I say that the reasoning on Tameside does overlap with the reasoning on the straight rationality challenge. Paragraph 59, I do not consider that failure to consider an alternative proposal that was more or less unformulated at the time of the decision can give rise to grounds for judicial review on grounds of process irrationality. Now, pausing there, if as a general statement, that's plainly wrong as a matter of law, because there will be circumstances in which something which is not fully formulated is critical to a decision, such that no reasonable decision maker could proceed without it. That's basic Tameside point.
Well, that's the point, isn't it? I mean, there appears to be a misunderstanding that process irrationality is the same thing as the Tameside duty. That seems to be what you're saying. That that the error in paragraph 59 is that process irrationality is being elided with Tameside, but then the judge goes on under ground 2 to decide that the Tameside duty has been satisfied. Yes,
he does. I mean, just to be clear, what my position is that Tameside is an aspect of procedural rationality, and that there are, of course, other aspects. We see, perhaps we just look briefly at the Law Society decision in the authorities bundle. Which is tab 4, page 42.
Yeah.
Apologies, no, that's the that's Tapala. Give me one moment to find the correct reference.
I think you need page 66 of the authorities bundle.
Grateful. This is the divisional court decision, Mrs. Justice Carr as she was then, where it describes between F and G. So firstly, there's outcome irrationality. You know, my lord, I'm sure you're incredibly familiar with this, but just to make good the point, the second aspect of irrationality and unreasonableness concerning the process by which the decision was reached. The decision may be challenged on the basis that there was a demonstrable flaw in the reasoning which led to it. For example, significant reliance placed on irrelevant considerations, or that there was no evidence to support the reasoning, or that the reasoning involved serious logical or methodological error. Now, clearly the methodological error could include not not sort of fully interrogating or developing analysis of a particular alternative. I think actually the authority that I was intending to take you to, where it's formulated a slightly different way, was also KP, Mr. Justice Chamberlain. And that's in the authorities bundle, the relevant paragraph being paragraph 56, page 361.
Yeah.
And there you see process rationality, including the requirements that the decision maker must have regard to all mandatorily relevant considerations, no irrelevant ones, but is not limited to that. In addition, the process of reasoning should contain no logical error or critical gap. And then it goes on to cite Wells, Mr. Justice Saini, that does the conclusion follow the evidence, or is there an unexplained evidential gap or leap in reasoning? So again, we see the gaps in evidence being part of these formulations of process rationality generally. And my Lord, of course, then the Plantagenet case expressly applies at various stages the Wednesbury standard to whether a reasonable decision maker could proceed with their decision without a relevant piece of information.
So in other words, the decision maker, aside from mandatory material considerations, has a discretion to exercise rationally as to whether a factor, be it an alternative piece of modelling or the market rate for a home, is a consideration that they should examine.
They do have that discretion, and that discretion then has to be exercised.
Has to be exercised
rationally.
Yes.
So if it is critical to the decision, then it wouldn't be rational not to consider it.
Yeah.
And of course, if you have, and this is my core point on this before I move on, if you have a decision which turns on the extent of savings, you know there's this further saving that could be made, and you simply don't know whether it's very big or very small or something in between, then I say it's irrational not to at least require sufficient evidence for you to know where on that scale it sits. I should perhaps, so I'm sure if I don't, Mr. Oldham will quickly pick up on it, turn to the part of the judgment where the judge does refer to self-funders, and that's at paragraph 57 of the judgment.
So paragraph
57.
57, thank you.
Page 99 of the core bundle. And there we can see that the judge refers to, at the time there being 7 self-funders, clearly having done the analysis, the local authority realised increasing charging for those 7 would not result in the homes breaking even. So I accept that they did do analysis to that extent, nor would any increase likely to be realistically achievable to the fees paid by those 7 have made more than minimal contribution. We don't actually know that. There's no evidence as to what the realistic increase was. He then says it's likely that those who are self-funding would sooner or later find that their assessed assets depleted so that they became eligible to pay only a proportion of the charge. Well, my lord, that's right insofar as it goes, but it's actually neutral when one analyses it, because over time, sadly, most care home residents are only in a care home for a couple of years before they pass away. Some assets deplete. Other new residents come along with assets who then deplete over time. So the fact that at any given point, a particular self-funder might have depleted assets to the point where they no longer have to pay does not mean that when one takes an overall picture, that means that the payments are generally going to go down over time. And then he says, well, it is possible that other self-funders might emerge, not immediately possible to understand why they would. My lord, I already addressed you briefly on that point about how we know that these care homes were being talked about as candidates for sale or transfer for a number of years. There were lots of reasons why they wouldn't be immediately attractive places to go. But all of this is the judge speculating, because it's not an officer with knowledge of these things. But beyond the fact that I say there was some limited analysis to the scrutiny panel, this is not an officer saying, I think we could achieve something in the region of X, knowing the local market, and I think we could attract Y number of further self-funders, bearing in mind all our calculations are based on increasing to 90%. We simply don't have that. So, and then on the second point, which is staffing, so there are the two aspects, self-funding and staffing. On the staffing, we simply don't have any information as to what was actually meant in the December report and what that potentially could have achieved.
We still don't do. We don't have any idea what could have been. I mean, these care homes have been run for a number of years.
They have, yes.
Presumably on the basis of trying to run them as efficiently as possible.
Well, my lord, that's a point that Mr. Oldham takes against me, but that must be, I think there are two answers to that. First is that the officers, having looked at it, said in the December report that some savings could be made in respect to staffing. And second, what we don't see in the evidence, and the evidence does span a couple of years, we see a focus on disposing of these homes. So in that period, what there hasn't been is sort of rigorous analysis of where can we make savings. So, of course, any public body would want to run something as efficiently as they could, but what they haven't done is focused on or turned their minds to what particular savings can we make, at least in the period for which we have disclosure.
Sorry, I'm not really following that. Are you suggesting that whilst they've been, that the homes have been allowed to be run inefficiently while they've been focusing on selling them? Surely.
My lady, what I'm saying is that with any entity, be it a public or private entity, there may be certain times where directors or whoever it may be will sit down and look at where can we make specific savings. That hasn't happened. And it is notable that the focus has been elsewhere. I would also suggest that if one stands back and thinks about the practical reality of an authority that we're already told is overstretched, they're running things as they always have, so that there is actually no suggestion that they are having a sort of focused consideration on the savings that can be made whilst keeping them in public ownership.
I mean, on your case, it can't have been, well, we should try to do more to have permanent staff rather than using expensive agency staff. That can't have been the problem, because as you pointed out, where agency staff were used, there was an underpayment in relation to direct cost of staff.
My Lord, I don't want to speculate as to what that December report said, but I said we simply don't have evidence as to what it meant by that and what level of savings it would achieve. So those are my submissions on the first ground. If I can move then to ground 2, which is section 31 of the Civil Courts Act. Proceeding for the moment on the basis that the judge is right, I'll then respond to the points raised in the respondent's notice. What I propose to do is just take you to one of the authorities and then set out our case in a nutshell before going through the particular points raised by the judge in the judgment. The case I propose to take you to is, I'm not sure whether you pronounce it Hippolyte or Hippolyte, but either way, it's in the authorities bundle, tab 13, page 421. Decision of Lord Justice Singh, and the paragraphs I want to take you to start at paragraph 69, that's page 436. So it summarises or sets out the statutory test. 2A is obviously for refusal of relief, but nothing turns on the fact that we here were dealing with refusal of permission. The material test is the same. Then setting out quotation from Plan B Earth at 70, and just picking it up at 71, a further quotation from Plan B Earth. I'm taking you just to this authority because it's one of the most recent Court of Appeal authorities and cites the others, so I don't need to go through all of them. But in that passage, highlighting importantly, and some of these bits are in italics, that Parliament has not altered the fundamental relationship between the courts and the executive. In particular, courts should still be cautious about straying even subconsciously into the forbidden territory of assessing the merits of a public decision under challenge by way of judicial review. And then skipping over a sentence, it will often be difficult or impossible for a court to conclude that it's highly likely that the outcome would not have been substantially different if the executive had gone about the decision-making process in accordance with the law. Courts should also not lose sight of their fundamental function, which is to maintain the rule of law, and that the threshold remains a high one. And in my submission, that point about it often being difficult and the high threshold are important here. It's important that where there was a judgment to be made by the Cabinet, that the court shouldn't be straying into that forbidden territory of saying, well, there were lots of savings and obvious benefits regardless, and therefore I think this is what the Cabinet would have done or should have done. So paragraph 72 cites Bradbury. Again, this is an important passage, that it's not for the court to try and predict what the public authority might have done if it had not made the error. If the court cannot tell how the decision maker would have approached matters or what decision it would have reached if it had not made the error in question, the requirements of section 31(2)A are unlikely to be satisfied. And I say we were in precisely that territory of the court simply not being able to tell. then finally I just jump to paragraph 78. Now, I accept that the facts of this case are very different. This was a case in which the Secretary of State had failed to exercise a discretion at all, so you didn't have any reasoning. But Lord Justice Singh does say there that there was no evidence as to what the Secretary of State would have done if she had not committed the error of law which he rightly had held had been committed, and that there was no witness evidence or any other evidence filed by the Secretary of State as to the Section 31(2)(a) issue. Now, to be clear, I don't say that what was needed here is one or more members of the Cabinet providing a witness statement saying, if we'd have known...
Well, it wouldn't be admissible anyway.
No, well, exactly. But what I do say is that evidence is required of the significance of the error to the decision that was
before we even
actually
get
made.
there, what we need to be crystal clear about is what is the error?
Yes. So, my Lord, whatever prism through which it is categorised, and I'll certainly look at the authority specifically on officers' reports, but the error is using a figure for the cost of alternative private provision, which was 2 financial years out of date. And resulted in a figure for the headline savings against budget that was wrong by 40%. Put another way, but for the error, the report would have said that the savings against budget were, and I don't have my note immediately to hand the exact figures, but was around 500,000 rather than 800. So what we say is that the evidence for the court to be satisfied that it was highly likely it would have made no difference. You would need evidence of the significance of that error to the decision that was actually made. Now here, we have evidence, and it's clear from the face of the report that the primary justification from the officers for the sale was this saving against budget, this 800,000 figure. And we also have, whilst not put in evidence, a submission where the council are disavowing any suggestion that they were proceeding on the basis collectively that there had to be full cost neutrality or there could only be one outcome. So the combination of evidence and submissions we have is that this figure was central to the whole case. The actual saving is 40% less than said. And we know that somewhere along that continuum of savings, there at least could have been an outcome, which meant that the Cabinet said, yes, it's going to make some savings, but actually we don't want to do that because of the risks and because of the public opposition. What we have nothing on, and I accept this is common in local authority cases, but we have nothing on what the Cabinet actually thought about the risks, how much weight they put on having to save a particular sum, where the Cabinet would have drawn the line, weighing the concerns of their constituents, the objectively identified risks in the risk assessment, the impact assessments, against the obvious benefit of saving money to the council. We just don't know, and there's no indication in any of the documents about how the cabinet members.
Well, that's
would
why we
approach
break
that.
back to what I was saying to you earlier. The documents we have got and their reasons are
Yeah.
what's in the officer's report. We have to assume, for the purposes of any analysis, that that is their reasons, not that they accepted the officer's recommendation because they couldn't really care less about whether or not they were going to make any savings or not, but they just wanted to be shot at the care homes. We have to assume that what I'm being facetious, as I'm sure you appreciate. We have to assume that their reasons are mapped onto what is in the officer's report, and therefore your point about significance must be seen in the context of the officer's report and its reasons.
My Lord, I accept that that where the cabinet makes a decision which mirrors that recommended in an officer's report, that you take the officer's report as the basis for the cabinet's decision. But in my submission, we are in slightly different territory here, where we know that one aspect was central to the officer's report, but we don't know, in accepting those recommendations, what weight the cabinet gave to different aspects of it. And that makes it far harder for the court.
Why isn't the weight that they attach to it on the basis of analysis the same as the weight that was given by the officers in reaching their recommendation?
Well, my Lord, we say, firstly, you don't actually see really what weight the officers gave. The overall tone of the report is that the focus is on this headline figure, with the other matters being secondary. But I do say it's important because there is a democratic aspect to this, of the members of the cabinet ultimately being the people who have to weigh those different considerations and decide whether they accept the report or not.
But this makes it absolutely critical, doesn't it, to look at the jurisprudence in relation to how the court is to approach the situation where there are said to be deficiencies in the officer's report. And you've identified two principally, haven't you?
Yes.
The first deficiency relates to the figure given to the alternative, the costs of alternative provision, which were 2 years out of date. And the second is the report hasn't identified what the financial effect of the savings in the two areas that have been identified. So those are deficiencies in the report.
Yes.
But because the Cabinet's reasons, decision and reasons for it are to be taken as being what's in the officer's report, and because of all of what you say about the democratic accountability of the Cabinet, we do very much need to look at the jurisprudence, because courts have considered this, the extent to which the court is able to say that what is in the officer's report, deficiencies in the report, give rise to a public law error on the part of the counsel who's accepted that report. We do need to look at that, don't we?
My lady, I can certainly see the force in that, and I think the only way I can address it now is to offer to look in the brief period over lunch, but in all likelihood also to perhaps seek your indulgence to submit a short note on that point, but because I appreciate that.
Well, I think we may get to a point this morning where we can't really go much further without that.
Well, let's see where we get to.
See where we get
moment,
to.
yes.
Yeah.
So if I could perhaps now then just go to, so you have my submission on, I guess, twofold essentially. Firstly, that we say actually on the evidence that was available, which is the officer's report plus, not evidence in the technical sense, but the position that the counsel expressed in accordance with their duty of candour, that they were never proceeding on the basis that that it had to be cost neutral in order for there to be any outcome other than sale. So that's the first point. The second point is then this point about the separate absence of evidence of what the Cabinet themselves thought, on which...
Well, that is a really dangerous place to go, and there's plenty of authority that says you can't... I mean, the number of times where people seek to rely upon the transcript of the debate at a committee to decide what the committee were thinking or what was motivating their decision. I mean, there's plenty of authority that says that you should really steer away from that. So this is why I observed you. You're right. You can't have a number of... I mean, they would be inadmissible in the sense that they're ex post facto, and they'd also be inadmissible because I think it was Lord Justice Sheeman said in a case called Beebe, committees act collectively, and therefore you can't the court can't make findings as to what the committee were deciding. I think what you're trying to say, if I may suggest, is that the decision may well have been different as your submission, had they known that the saving was £500,000 and not £800,000.
I mean that's it in a nutshell. And I think, my Lord, perhaps if I can refine my submission in this way, I wasn't ever suggesting that the appropriate course was...
No, I know you weren't. But when you start to make the submission about, well, we don't know what weight members decide, that's when you're starting to peer into the minds of the creative dialectic process that is a committee making a decision. But you don't need to go that far, certainly the court isn't going to go that far in exercising its discretion.
No, and I think this perhaps, though, is the important point then, that it's why the court should exercise greater caution in refusing relief or refusing permission under Section 31, where you do have those two steps. So the authorities, as I understand them, and I will go and look in more detail, but are not about application specifically of the no difference.
No, they're about how you should approach your ground one.
At the stage of determining lawfulness. And if the court has then determined that a report was unlawful, I would suggest it's going to be very unlikely that they would be able to determine that it is highly likely that this error would have made no difference, because by definition, in local authority cases and other cases where decisions are made on the basis of a report but by a collective body, you would be entering the realm of speculation to say what that body would have made of the error. And that's very different where you actually have the decision makers' personal reasons and can directly see what they've determined. So I propose now to look at what the judge said about this. So starting at paragraph 147 of his judgment, which is core bundle core bundle 127. Start at 1245, where he talks about the claim potentially standing to succeed on the basis of the non-updated figures and sets out what they were at 146. Then at 147, the point which we've already gone to about primarily relying on savings against revenue, and then other factors, overspend against budget, avoiding obligations of capital investment, and benefit of potential capital receipt. Now, of those factors, the judge then goes on to find that the capital investment figure is not robust. That's at 151. And at 152 talking about capital receipt being in the realms of speculation. And even if we just go back to what the report itself said, it talked about we could receive a capital receipt. So clearly the report itself is not putting a lot of weight on that. And similarly, the figure of 1.4 million is again expressed in could rather than would. So that just on an ordinary reading of the report itself, these are the more tentative suggestions which weren't the core aspects of the decision. So if we take out those or give them limited weight, then we are left with just that headline savings figure, plus this potential point about avoiding overspends. Now, on the avoiding overspends, I've already addressed you how there wasn't a proper evidential basis for saying that there would be avoidance of overspends. And then you're left just with that headline figure, which is 40% less. And I say that is clearly on its face significant. It's a very big difference. And we simply don't know what the Cabinet would have made of it. So turning to paragraph 156. There the judge talks about how conducting this exercise without straying into impermissible territory is not far from easy, that the Council's decision was based on savings calculated on the basis of what I found to be legally erroneous. He then says that the consequence was the savings figure would be reduced by 350,000, but that there would still be a saving in excess of 500,000. Well, that's true insofar as it goes, but it doesn't answer the question about whether that difference of 40% would have been significant. The next sentence, we then see some of the reasoning, and what I say is flawed reasoning, because it notes from Mr. Buta's evidence that it was of the view that it was the view of officers that a 4% increase in the rates would not have had a material impact. Well, there's clearly a big difference between 4% and 10%, and I say that we have no evidence as to what the officers even thought of 10%. And in any event, Mr. Buta's witness statement is not part of the report that can be treated as the Cabinet's reasons. And we simply don't know whether the Cabinet would have considered either 4 or 10% to be material. At 157, there's then reference to that avoiding unbudgeted expenditure, which I've already addressed you on, and I say was an error. And then the judge says this at 158, which in my submission is where he is straying into that impermissible territory, because he says that there's no evidence before me of a position in which the reduced amount of savings might have made continuing operation by the Council more attractive. Well, we simply don't know what would have been more or less attractive because there's no evidence on that. There's nothing in the officer's report or elsewhere that says we must achieve a saving of at least X. And so it's simple speculation to say what would and would not have been attractive. And then there are matters within institutional memory of the Cabinet. Again, I accept that they are background to the decision, but in circumstances where the local authority disavows having to make savings which lead to cost neutrality, they don't provide an answer. And so in my submission, none of those factors individually or cumulatively can justify the conclusion that the court reached. It simply wasn't in a position to say what the outcome was likely to have been.
Where's the evidence on the deterioration of the financial position since the previous report?
My Lord, I think it was in one of the witness statements of Mr. Booter. Perhaps I can check that and come back to you on exactly where it is, but I do recall seeing
There's
that.
nothing in the reports about the worsening financial condition, is there? We have no detail about how much worse it was.
No. And so, my Lord, to the extent that it wasn't in any of the reports, I'm not sure it would be right to rely on that at all, in fact. But I'll need to check.
Well, it may be something of which it may be said against you. Members would have been acutely aware.
My Lord, I don't think I can take a big point on that issue. So those are my submissions on the two grounds. I'll now then move on to the issue of the respondent's notice. There are 2 points here. The pleading point, and then the question of whether the judge was right to find failure to provide an updated figure in the February report was unlawful. It may be that on that second point, both Mr. Oldham and I need to go away and consider the authorities, but I will address you in detail on the first point and make such observations as I can on the second. So my submission on the pleading point in a nutshell is that the decision about the case, whether the case was sufficiently pleaded, was a matter of case management for the judge. He found that it was sufficient, and importantly, he found, having considered all of the local authorities' submissions and considered what additional evidence they'd filed before the hearing, he found that there was no prejudice. And that's not directly challenged. That's clearly important. In making his decision, he considered all parties' arguments. He cited the relevant authorities. And in my submission, there's simply no basis on which this court could interfere with his decision, or could properly interfere with his decision. If I can go first to the law and Talpada, which is Authorities Bundle, tab 3, page 41. Well-known passage from Lord Justice Singh, starting at paragraph 67. He talks there about procedural rigour in public law. Cannot be emphasised enough that public law litigation must be conducted with an appropriate, and I emphasise appropriate, degree of procedural rigour. He recognises that public law litigation cannot necessarily be regarded in the same way as ordinary civil litigation. So this complaint shouldn't be treated in the same way as if a claimant in a tort case had not pleaded something in their particulars of claim. And that's because it's not only the private interest of the parties which are involved, there's clearly an important public interest which must not be overlooked or undermined. So that is central to the considerations that we're dealing with public law and the importance of, particularly in something as sensitive and as controversial as this, that arguments of potential unlawfulness should be properly heard and determined. The procedure must not become the master of substance. However, he obviously goes on to say that fairness and the orderly management of litigation requires that there must be an appropriate degree of formality and predictability in the conduct of public law litigation, as in other forms of civil litigation. Then jumping to 69, at 68 he talks about unfortunate trends of cases evolving. Then at 69, these unfortunate trends must be resisted and should be discouraged by the courts using whatever powers they have to impose procedural rigour. Then it says courts should be prepared, but it doesn't say always and in all circumstances, to take robust decisions and not permit grounds to be advanced if they've not been properly pleaded or where permission has not been granted to raise them. Now, pausing there, on the facts of Talpada, which is where this general guidance is made against a background of a particular case, the appellant was not shut out of raising any of the arguments that the appellant wished to raise on appeal, as far as I can see on my reading of the judgment. So this is not authority for the proposition that evolution of a case in public law can never be permitted. It's simply an important statement of general principle that the court should have regard to the need for procedural rigour. Of course, this judge did have regard to that and specifically cited this authority in his judgment. I'm going to come to the judgment in a moment, but just in terms of the facts, the way that the arguments developed in this case reflect the fact that information about how the local authority calculated its figures, and importantly, information about the fact that the general payments it made had increased each financial year, was only disclosed after the proceedings were issued. So I'll take you to the relevant witness statements, both after the statement of facts and grounds in May 2025. So in Mr. Buta's first witness statement, which is supplementary bundle, page 32, paragraph 65.3, it describes how there had been a 4%, an increase of around 4% applied to the council's rates to providers of dementia care from April 2024. So that's the first we knew about the 4% rise. Then this rise of 10.7%, or cumulative rise of 10.7%, only becomes apparent in a subsequent witness statement, and it's actually an exhibit to that witness statement where we see the further increases. That's Mr. Buta's second witness statement of the 25th of July 2025, and it's page 70 of the supplementary bundle, paragraph 17.5, and we actually had to infer it. It wasn't stated in terms, but there it talks about the current standard rate from April 2025 being 816.47. So we then had to go away, look at the exhibit and work out what percentage the rates had increased by. So it's only through this process of disclosure that the specificity of the complaint emerges, but the generality of the concern that the comparator was erroneous because it didn't reflect rates that would actually be paid was apparent from the outset. And we can see that the core bundle, page 264, paragraph 28, that the analysis by which the February report calculated the cost savings was itself flawed, and it includes B, when calculating the external cost to D post-sale, the rate per week used by D was erroneous. And then it also says at odds with empirical facts established by local market evidence. So if we look then at what the judge said about this, core bundle page 84, paragraph 9, says that the central thrust of the complaints has been maintained throughout, albeit with some refinements and changes in response to material disclosed by the council. In my submission, that is a fair and accurate summary. He then sets out what the arguments were and how they, at 11, all except B, and B we're not concerned with here, all except B can be found in the grounds section of the Statement of Facts and Grounds in some form. And as regards what will prove to be the central feature of this case, namely the rate used for comparison purposes, I consider that ground 28B, that when calculating the external cost of the defendant post-sale, the rate per week used by the defendant was erroneous, etc., is sufficiently apt to encompass both the suitability of the rate used for this cohort of residents and any error caused by being 2 financial years out of date. So he says it's sufficient, and importantly, at the bottom of paragraph 13, that Mr. Oldham met under process both what he regarded as the pleaded and the unpleaded part of the case, and there was no sense in which the council has been taken by surprise or placed in difficulty by the contents of the claimant's skeleton argument. And in my submission, that is crucial. There has been some evolution, but if there's been no prejudice, then bearing in mind we're dealing with public law litigation, it cannot properly be said to have been wrong for the judge to take the course that he did. Finally, then, on the merits of the decision. And
just before you turn to that,
yes.
Give us a second. We think it might be sensible if we break now for an early lunch and come back in an hour's time, so we don't lose any time during the court day, so that you can address this point with the benefit of whatever authority you want to draw to our attention at 25 to 2. Is that acceptable to both of you?
Certainly not.
Yes. How are we doing for time otherwise?
My Lord, I mean, I'm almost there with, I just got that one final part, really, the merits of the decision. So I won't be longer than another, certainly not more than half an hour.
Right. Well, we'll resume at 25 to 2 o'clock.
My Lord, can I just ask if there were any particular authorities that you had in mind that I could, let's go to.
Yeah, the authority that I was referring you to earlier is the case of Mansell in the Court of Appeal. The reference for it is 2017 EWCA Civ 1.1.4. It's paragraph 42, where Lord Justice Lindblom sets out the principles in a planning context of how one judges the quality of an officer's report.
Thank you.
All right, in favour?